Chapter 10. Corporal Punishment. The teacher who contracts to manage a public school undertakes to do something more than merely to prescribe lessons and hear recitations. The teacher assumes to govern the school, to maintain quiet and order in and about the schoolhouse during school hours, and to compel such conduct on the part of the pupils as shall most conduce to their own welfare and that of the school as a whole. The authority to command this would be nugatory if the teacher were not armed with some coercive power. We accordingly find the law to be that a school teacher stands in loco parentis in relation to the pupils committed to his charge, while they are under his care, so far as to enforce obedience to his commands, lawfully given in his capacity of schoolmaster, and he may therefore enforce them by moderate correction. He undoubtedly has the right to chastise his pupils for any conduct which interferes with the order and discipline of the school. If, however, the teacher administer more than a reasonable punishment, he becomes criminally liable, and the absence of actual ill will, vindictive feeling and hatred, will not excuse him. Malice is essential, but it may be inferred from the circumstances. Everyone is presumed to intend the natural and necessary consequences of their acts. Therefore the intent of the assault may be and should be determined from the excessiveness of the battery which immediately followed. The teacher must exercise a reasonable discretion, and must be governed as to the manner and severity of the punishment by the nature of the offense, the age, size, and apparent powers of endurance of the pupil, and it is a question for the jury to say whether the punishment is excessive. A schoolmaster is not relieved from a liability for damages for the punishment of a pupil, which is manifestly immoderate and unnecessary, by the fact that he acted in good faith and without actual malevolence, honestly thinking that the punishment was proper and necessary both for the welfare of the pupil and the discipline of the school. There are some cases which hold that in order to render a teacher liable criminally the circumstances must show strong reason to believe he was actuated by bad, malevolent motives, using his legal authority for the gratification of a mind bent on mischief. The weight of carefully considered decisions would perhaps require the law to be stated thus: malice is necessary to make a teacher liable for the castigation of a pupil, but the malice may be presumed from the circumstances. If the punishment is inflicted with unreasonable and immoderate violence, the teacher is liable, although no wicked, malicious intent existed. Where the teacher acts wantonly for the gratification of wicked, malevolent motives, he is liable, no matter how moderate the punishment may be. In a case in North Carolina, the defendant, a school teacher, was indicted for an assault and battery. After using mild measures toward a little girl of 6 or 7 years without success, the teacher whipped the child with a whip to such an extent as to leave marks which passed away in a short time. 2 marks also were found to have existed, one on the arm and one on the neck, which appeared as if made with a larger instrument, which also disappeared in a few days. The inferior court instructed the jury that as the child was of tender years, if they believed the defendant had whipped her, with either a switch or other instrument, so as to produce the marks described to them, she was guilty. On appeal the Supreme Court held that this instruction was erroneous, and that, under the circumstances, the punishment was not in excess of the teacher's authority. The opinion of the Supreme Court was delivered by Gaston J., who said, "It is not easy to state, with precision, the power which the law grants to schoolmasters and teachers with respect to the correction of their pupils. It is analogous to that which belongs to parents, and the authority of the teacher is regarded as a delegation of parental authority. One of the most sacred duties of parents is to train up and qualify their children for becoming useful and virtuous members of society. This duty cannot be effectually performed without the ability to command obedience, to control stubbornness, to quicken diligence, and to reform bad habits, and to enable him to exercise this salutary sway, he is armed with the power to administer moderate correction when he shall believe it to be just and necessary. The teacher is the substitute of the parent, he is charged in part with the performance of his duties, and in the exercise of these delegated powers is invested with his power. The law has not undertaken to prescribe punishments for particular offences, but has contented itself with the general grant of the power of moderate correction, and has confided the graduation of punishments, within the limits of this grant, to the discretion of the teacher. The line which separates moderate correction from immoderate punishment can only be ascertained by reference to general principles. The welfare of the child is the main purpose for which pain is permitted to be inflicted. Any punishment, therefore, which may seriously endanger life, limbs, or health, or shall disfigure the child, or cause any other permanent injury, may be pronounced in itself immoderate, as not only being unnecessary for, but inconsistent with, the purpose for which correction is authorized. But any correction, however severe, which produces temporary pain only, and no permanent ill, cannot be so pronounced, since it may have been necessary for the reformation of the child, and does not injuriously affect its future welfare. We hold, therefore, that it may be laid down as a general rule, that teachers exceed the limits of their authority when they cause lasting mischief, but act within the limits of it when they inflict temporary pain only. When the correction administered is not in itself immoderate, and therefore beyond the authority of the teacher, its legality or illegality must depend entirely, we think, on the quo animo with which it was administered. Within the sphere of his authority, the master is the judge when correction is required, and of the degree of correction necessary, and, like all others entrusted with a discretion, he cannot be made penally responsible for error of judgment, but only for wickedness of purpose. The best and wisest of mortals are weak and erring creatures, and, in the exercise of functions in which their judgment is to be the guide, cannot be rightfully required to engage for more than honesty of purpose and diligence of execution. His judgment must be presumed to be correct because he is the judge, and also because of the difficulty of proving the offense, or accumulation of offenses, that called for correction, of showing the peculiar temperament, disposition, and habits of the individual corrected, and of exhibiting the various milder means that may have been ineffectually used before correction was resorted to. But the master may be punishable when he does not transcend the powers granted, if he grossly abuse them, if he use his authority as a cover for malice, and, under the pretext of administering correction, gratify his own passions. The mask of the judge shall be taken off, and he will stand amenable to justice as an individual not invested with judicial power. In an Iowa case it was held that any punishment with a rod which leaves marks or welts on the person of the pupil for 2 months afterward, or much less time, is immoderate and excessive, and the court would have been justified in so instructing the jury. In the same case the following instruction was held not erroneous: the legal objects and purposes of punishment in schools are like the objects and purposes of the state in punishing the citizen. They are threefold: first, the reformation and the highest good of the pupil; second, the enforcement and maintenance of correct discipline in school; and third, as an example to like evildoers. And in no case can the punishment be justifiable unless it is inflicted for some definite offense or offenses which the pupil has committed, and the pupil is given to understand he or she is being punished for. And if you find from the evidence that the punishment in this case was inflicted upon the prosecutrix without her knowing what she was being punished for, then the punishment was wrongful on the part of the defendant. Punishment inflicted when the reason of it is unknown to the punished, is subversive and not promotive of the true objects of punishment, and cannot be justified. In sustaining this instruction the Supreme Court says, the object of all punishment must be to accomplish the purposes specified in the instruction. The definition is an admirable one, and cannot, we think, be improved. If the pupil does not know why the punishment was inflicted, reformation cannot be expected therefrom. Just the contrary result might be expected. Counsel mistake the meaning of the instruction. It does not require the teacher to state to the pupil in clear and distinct terms the offense for which he or she is being punished. It only requires that the pupil, as a reasonable being, should understand from what occurred for what the punishment is inflicted. The teacher must often act promptly to maintain order, without waiting for the views of the directors or trustees. Where a pupil, in school hours, places himself in the desk of the instructor, and refuses to leave it at the request of the master, such pupil may lawfully be removed by the master, and for that purpose he may immediately use such force, and call to his assistance such aid from any other person, as may be necessary to accomplish the object, without the direction or knowledge of the superintending committee. And the case is the same if the person is not a pupil, but one having no right in the school. When the relation of schoolmaster and pupil, or any similar relation, is established in defense of a prosecution for assault and battery, the legal presumption is that the chastisement was proper, and this, to warrant a conviction, must be rebutted by showing that it was excessive or without cause. Where the relation of schoolmaster and pupil or parent and child exists, and the chastisement is not without cause, it is not the infliction of punishment which constitutes the offence, but the excess, and what shall be deemed excessive is not a question of law for the court, but is a question of fact to be determined by the jury. In a criminal prosecution the offence must, of course, be proven beyond a reasonable doubt, and if there is any reasonable doubt that punishment administered by a teacher was excessive, the teacher should have the benefit of the doubt. It has also been held in a civil suit against the teacher, that if there is any reasonable doubt that the punishment was excessive, the teacher should have the benefit of it. So far as the question of jurisdiction is concerned, while there is a dearth of judicial decisions as to the exact limits of the teacher's jurisdiction, yet the spirit of the decisions is that the authority of the schoolmaster extends over the person of the pupil from the time the pupil arrives on the school premises until it leaves, and over the school premises both in and out of school hours, and also that for conduct out of school hours and off the school premises, in violation of a rule of the school, and which conduct has a direct and immediate tendency to injure the school or its discipline, the authority attaches and the pupil may be punished therefor. But whatever punishment is to be administered must be inflicted on the school premises. Although a teacher has in general no right to chastise a pupil for misconduct committed out of school after the dismissal of school for the day, and the return of the pupil to his home, yet he may, on the pupil's return to school, punish him for any misbehavior, though committed out of school, which has a direct and immediate tendency to injure the school or subvert the teacher's authority. This was held in a case in which the pupil, a boy 11 years old, an hour and a half after the school had closed for the day, and when he was at his home, and engaged in his father's service, used saucy and disrespectful language to the teacher in the presence of some of his fellow pupils. For this the teacher whipped the boy next morning on his return to school. The court, sitting in full bench, and upon argument and careful consideration, sustained the action of the teacher, and in doing so used the following language: but where the offence has a direct tendency to injure the school and bring the master's authority into contempt, as in this case, when done in the presence of other scholars and of the master, and with the design to insult him, we think he has a right to punish the scholar if he comes to school again. There was no prescribed rule in that respect, and the court passed directly upon the teacher's right to maintain respect for his authority, even as against acts done out of school which are directed against his authority. If a person who has attained majority voluntarily attends school, creating the relation of teacher and pupil, he thereby waives any privilege of age, and subjects himself to like discipline with those who are within the school age. Such pupil may be punished for refractory conduct, provided the punishment be reasonable under the circumstances. It has been held in Wisconsin that a teacher was not authorized to inflict corporal punishment upon a child for the purpose of compelling it to pursue a study which it was forbidden by its father to pursue. In this case, however, the teacher assumed the right to control the child's studies, and there was no rule of the school board requiring the pupil to pursue the study which his father had forbidden. It is expressly stated in the opinion, that this decision is not intended to interfere with the duties of the school board in making and enforcing proper and reasonable rules. If the rules of a school prescribe certain studies, and require attendance at particular hours, and the parents may not excuse therefrom, yet the teacher should not in such case resort to whipping the pupil for failure to pursue the studies or attend at the hours fixed by the rules. The remedy in such case is expulsion from the school. In New Jersey, corporal punishment is forbidden by statute. In England it has been held, that where a schoolmaster wrote to a parent and obtained the parent's consent to beat the pupil severely to subdue his alleged obstinacy, and the teacher beat the boy for 2 hours and a half secretly in the night, and with a thick stick, until the pupil died from the effects of the beating, such teacher was guilty of manslaughter only, no malice having been proved.